Thank you all so much for joining for this second in our series on navigating immigration casework. For those of you who've been to some of our webinars before, I'm Ann Meeker. I'm Deputy Director at POPVOX Foundation. I am a former caseworker, a former Director of Constituent Services, a full-time Congress nerd and full-time casework nerd for a nonpartisan team at POPVOX Foundation. This, as we mentioned, this is the second in our series, in our Casework Navigator series on navigating immigration casework, which we understand is always and forever one of the most difficult areas of congressional casework, one of the most complex, one of the most demanding, and especially no more so than right now with the rules, with the circumstances surrounding immigration casework changing so rapidly. So again, we are delighted and honored to be joined by the American Immigration Lawyers Association to help us sort out all of this. This is part of our series talking to civil society groups about just how can caseworkers navigate this moment where things are changing so rapidly, and how can caseworkers really rely on nonpartisan civil society groups like AILA to figure out and build their own resource networks. Figure out who in your district, in your state, can you rely on for information, for advice, to really kind of support your casework practice and help make sure that you are serving constituents as best as you can. So this is the second in our series. Last week we talked about business and other types of casework. So this week we are focused on humanitarian and family-related casework. So we are going to kind of tightly bound and really focus on that area today. So if you missed last week, please feel free to go back and watch that webinar that is up on our website at POPVOX, POPVOX.org/casework. And it was wonderful, and I can't recommend it enough, taking time to go take a look at that. And so as we said last week, I handled every area of casework except immigration. So I want to make sure that you guys have a host who actually knows what she's talking about and can ask the good questions. So I am so delighted to be joined by Meghan Vogel, former senior immigration casework lead for the office of Senator Sherrod Brown. We have her for the last few days before she goes on to start the next phase of her career. So Meghan, thank you again for being with us. Over to you.
Thank you so much, Anne. I really appreciate it. I'm so excited to be joined by AILA today, too, to kind of talk about humanitarian and family casework. Family-based petitions are especially complicated because, it's not just one type of application for every family member. There's different family-based preference categories, and you can get into the visa bulletin, which kind of make complications. And then on the humanitarian side of things, you have, cases like TPS and USRAP, with, United States Refugee Admissions Program, and just how vastly different you kind of have to interact with federal agencies depending upon the type of humanitarian case that you're dealing with. So we're happy to be joined by Blanca Hernandez and Cristina Santiago today. Blanca currently serves as AILA's Supervisory Policy and Practice Associate after several years liaison directly with AILA members, attorneys on case assistance and trend and data analysis. And Cristina was born and raised in Puerto Rico. She obtained her JD from the University of Puerto Rico School of Law in 2012 and her Bachelor of Arts degree in Political Science from the University of Puerto Rico, Rio Piedras campus. Since 2018, Cristina has practiced immigration law exclusively. She has experience with complex family and humanitarian-based immigration, including criminal analysis, appeals, and deportation defense. Cristina is an active member of AILA and currently serves as a member of the USCIS High Impact Adjudications Assistance Committee. So we can't wait to hear from them today. And then caseworkers, also just a reminder to please use the Q&A function if you have any questions today. We have a lot to cover, so we'll do our best to get to it all.
Yes. Thank you, Megan. I probably want to start off with doing something like quick and dirty, kind of doing a quick review of last week in terms of a little bit of like the case assistance process. Just to remind folks that anytime a constituent comes to you, you shouldn't be their first step on the ladder. They should definitely have done some work prior. So USCIS always requires and definitely is a lot happier if you reach out to them first, give them the opportunity to attempt to resolve the issue. Sometimes it can be just the left hand not talking to the right hand. And so they definitely want to be given the opportunity to correct it. There's situation after situation that we just don't know the back end in terms of what is happening. So definitely make sure that constituents, attorneys, whomever it is that you're working with, has already done their due diligence on the back end. Like, have you reached out? Have they responded? Even if they didn't respond, how long has it been? Like, USCIS generally requires a 30-day turnaround time. Even if they respond faster, there's times when they do take the full on 30 days. So make sure that you do provide USCIS at a minimum those 30 days to provide you a response. That being said, because there were a lot of amazing questions, some that required a lot of detail, we may not necessarily get to go through all of them, or not necessarily as detailed. So we're gonna kind of try and cover as much. I think one question that came in last minute, but I thought was extremely important to mention was, what do we tell constituents and what can we promise? I would say that the best thing I can recommend on the end of somebody working case assistance is that you never promise anything, because you can't really get to a point of promising them that you're going to resolve it, or that, that you can't really do or resolve the issue. And so like all you can really say is, I promise that I'm going to work as hard as I possibly can to figure something out. But it is never to resolve. It is never to get them a response. It is never to like actually resolve the issue, right? Like those are things that we just can't respond or promise on. And so I would say, one, as a caseworker, and two, as an immigrant, don't ever promise me something that you may not necessarily get to. And so that being said, wanted to do a quick run through in terms of the differences of how to request assistance from the agency, and how it differs, particularly for humanitarian cases, as opposed to what we spoke on last week, right? Like generally last week, employment, student, all of these cases, generally the first place we go to is directly to USCIS, and that's the part of the agency who's going to provide us a response. And so while yes, all of these offices or case types are covered under USCIS, they all have different offices. And so, for example, humanitarian cases, that's not something that we generally go to in terms of directly just USCIS, like we would do a family or a relative type of visa. And so for that, there's been, at least during the last administration, there were some changes. We don't know what changes are going to come about in terms of how these are processed, but the way it works today is that there is a humanitarian unit that particularly processes humanitarian style cases, VAWAs, USCIS, and we'll go a little bit into those. And they are they were the only ones within the agency who were allowed to provide any kind of update or response in terms of anything related to a case. And the reason why this is the case, it's because it is for the protection of the applicant. To make sure, especially if it's a VAWA or T case, like they need to make sure that at the end of the day, the applicant is protected. And so you will sometimes hear that they also don't want to discuss asylum related cases, not necessarily because they fall in the humanitarian unit, but because sometimes there is also some sensitive matters related to the cases. And so you may get to the point where they're not going to want to discuss it with you. And they'll ask that you reach out directly to the asylum office or whomever is processing the case at that moment. And so some of the cases that we for sure know that the humanitarian unit covers, we know our VAWAs, UTs. We know that the best way to communicate with them is through email, calling. There's they do have I guess like a number that goes directly to them. I cannot promise you that it'll be up the first or the 10th time that you call. And so what we really always recommend is to continue to follow up, right? And I think one thing that I mentioned last week was a lot of the time we hear from attorneys like, oh, yeah, we reached out for congressional casework assistance, but the moment the agency like didn't respond or responded something that had nothing to do with our case, that's what they allowed us to walk away with. Like, okay, here's the response the agency provided, and this is as much as we could do for you at this moment. And so I think in terms of when it comes to some of these folks, especially when it's a humanitarian case, I think the last thing we want to do, because we do not want to provide a disservice to these folks, is to let them walk away with something that doesn't necessarily answer, right? Because again, going back to what can we promise? We can only promise that we're going to work as hard as we can. And so making sure that we follow up if need be. Not sure if you all have like a limited time of amount of times that you're able to follow up, or you're only given like a certain time period to work on every case. And so that is something that you might want to have a conversation within your respective offices, right? Like, is this something that we might potentially want to shift if that is the case? And if not, then if you all are kind of like a free-for-all kind of thing, then definitely make sure you continue to follow up on them. Another way to follow up on these cases is paper inquiries. A lot of the times, that's the only way you're going to have some kind of evidence that this was actually followed up on, how many times, what you asked, etc. And so that provides you a paper trail on anything that you might have asked the agency about. In terms of asylum, there's of course the asylum office, but we also understand that there's two types of asylum, right? Like there's affirmative asylum and defensive asylum, and the asylum office will only deal with affirmative asylum cases. And so affirmative asylum means that the person is not currently in removal or deportation proceedings. Their case is not currently in the jurisdiction of the immigration court. And so that means that these people are going to go directly into an asylum office within their jurisdiction. They're going to apply. They're going to go through an interview, and whatever needs to happen is going to happen through that process. A lot of the time, if you need to follow up on whatever the case might be, you will be required to follow up directly with the asylum office, because their office is not going to provide or share that information of these asylum cases with the general processing of other related cases. And so like just making sure that we're following up with the correct offices. If for whatever reason the affirmative asylum case is not approved there, then it is referred to immigration court. And once it is referred to immigration court, that's when we now call it defensive asylum. And so it's not that they lost the opportunity at actually requesting asylum, is that they're given this like second look at their case, because maybe the first time around all of the information wasn't available, and that's why their case might not have been like able to be adjudicated at that point, right? And also because a defensive asylum allows that there's only within that first year mark that the person has been inside of the US, that's the time period in which they are required to file for asylum. And so that defensive asylum provides them that, you could call it leeway, to continue to advocate for themselves past that 1 year. And so it now provides an immigration judge to provide the final decision. And so if for whatever reason during the first year documents were not available, witnesses were not available, whatever the case might have been, it's probably going to be available during that period, right? And so just making sure that there's this understanding that defensive asylum works a bit differently. There's no interview that you come into, rather you are placed on the stand and you are asked questions by now an actual attorney on the part of the Department of Homeland Security. And then you ideally also have an attorney present there who is speaking also, not necessarily on your behalf, but making sure that your rights are respected as an asylum applicant. And so that the asylum jurisdiction tends to be even within the immigration courts, very similar to in terms of if you live in a certain area, then you are also associated with the immigration court from that area. And if you end up moving, you have to make sure that you provide that update to the immigration court, and even if it is also to USCIS, your address always has to be updated to make sure that that case follows you. Otherwise, the last thing we want is that these folks end up being removed in absentia, and meaning that they just didn't show up to their hearing. And it may be for a mistake of like, oh shoot, I forgot to change my address and I didn't get the notification that I had a hearing coming up. And so that's kind of like the quick and dirty on that. And so talking about immigration court, we know that this is, I guess, a topic of conversation that happens across throughout all administrations, right? Like detention. And so we want to make sure that that we also understand that there's two types of dockets within the immigration court, or as we generally call it, like EOIR. And so EOIR has these dockets that are for detained and non-detained individuals. And so detained individuals mean that they were detained for whatever reason, and they are advocating or they're fighting for their case while being detained. And so being detained does not prohibit an individual from filing some kind of benefit that may eventually not only get them released, but ideally also provide them an immigration benefit that allows them to stay inside of the US. And so for non-detained cases, a perfect example is folks who were referred there for a second look at their asylum case, right? Or for somebody who is providing something called cancellation of removal through an immediate relative. And so this is, I guess, goes into another subject, but these are folks who are out, not in detention, and are continuously going to hearings until their case is decided. And so we know that there's many of these cases. A lot of the times there's huge backlogs with both types of detained, non-detained individuals. And so one thing that we also have to make sure that we are fully aware about is that if there is a delay, a lot of our constituents will probably be nervous because they think, well, it's been 2 years or it's been 3 years and I haven't heard back. Can you follow up? And it doesn't mean that they forgot about them. It just means there's a backlog, right? And so we just don't always know when these cases are going to move along. And so a lot of the time it could depend on the administration. A lot of the time it could just be that there is a massive wave of folks who are currently in removal proceedings. And so there may be many situations why there is a backlog. And then speaking of folks in detention, we know that currently there is a huge worry among detention. And so there's, I wouldn't call it right now necessarily raids, but there are a lot of arrests happening. And so I don't think that I've heard that there has been like a raid at large, that they just came into a community and arrested everybody at sight. But we know that we are seeing arrests in a lot of places, many of them. And so the first thing that loved ones want to do is find where their loved one was taken, right? And so how do we do that? How do we provide relatives like the information? How do we assist? And so there's something called the ICE locator system that allows for once that person has been actually placed into the system, allows us to locate exactly where they're at. It gives us the information of their deportation officer or the officer who currently is processing their case. And so the ICE locator system is really good and works really good for the most part, so long as the individual has already been placed into the system. And so I think the bigger worry sometimes comes about when when individuals aren't automatically placed into the system. And so the thing is that it takes maybe about 48 hours for somebody to be placed into the system. So if somebody isn't found right away, there's not necessarily a need for panic. Like, oh, they've already been removed, or, you know, we don't know that necessarily, but it does take at least a day or so for individuals to be placed in the locator system. And so making sure that, especially if, I guess also considering kind of like the current situation in terms of detentions, I think one of the best things that we could probably recommend to any constituent, or to, you know, even for us, to any of our attorneys, like, make sure that that if your constituent doesn't have an attorney, at least have one ready. They don't need to have an open case with anybody. At least make sure that somebody has provided them like a quick overview of their case, and that they have a Form G28 signed and ready in case they are detained, or an EOIR 28, which is basically the same thing, but for ICE. And so just to make sure that there is some kind of representation document ready, right? So that if the family isn't able to kind of fully advocate for their loved one, that they have an attorney ready in that hand who can help advocate for them. And then, of course, at some point, they may come to you to also help them advocate for these folks. Wanted to do a quick thing in terms of the differences between VAWA UTs. So VAWAs are Violence Against Women's Act. And so what this particular bill that or law that kind of gets redone every year, every congressional year, is it protects, it initially did start out just to protect women, but it protects anybody within a family unit. And so the reason that it's protected, it's, for example, I married a US citizen, and at some given point down the line, I am now the victim of domestic violence, and my immigration status is being like thrown in my face. Hey, you know, I'm the reason you're still here. Without me, you're not going to be able to do all of these procedures, etc. Right? And so as a way of protecting myself, I would end up having to seek, because I know that I'm still in the process of immigration, I would now have to seek an avenue to attempt to petition on my own without my potential abusive spouse knowing that I am still seeking relief. And so now I am going through this VAWA route, and it could be men, women, anybody, right? And just making sure that we are safely seeking this kind of side benefit that will allow us to safely maintain ourselves in the country, and that our spouse or abuser isn't, you could say, like, threatening with, well, I'm going to get you deported if you don't do what I tell you, right? I think one very common, not common knowledge, is that it also protects, for example, like parents or children of a US citizen or legal permanent resident. And so for example, I was brought here, and my child, you know, told me that they were going to help me, and they brought me to this country, and then they told me they were going to take care of me. But here I am, all of 80 years old, and it turns out that the reason my child brought me to this country was so that I could cook, clean, and take care of their children. And now I'm not allowed to leave the house. You know, I probably am beaten because I don't do what I'm being told, etc. And so it also allows this parent to seek that same type of benefit, right? Similarly for a child, same scenarios. The way in which it differs from a U visa case is that a VAWA case doesn't necessarily need to have a police report per se, in terms of how to prove that something is happening to me. There does need to be some kind of like maybe medical or something that you could prove, like I was in danger, in order to move this case along. A U visa, for example, the perpetrator never has had to have been in the US legally. They did not have to be a US citizen or a legal permanent resident. It could be another undocumented person who, you know, decided to cause you harm. And so at this point, the U visa, we call it the, like, one of the best visas that you could potentially ever seek. Because if you, for example, came in, you know, when you were a child and you came in with your parents and you crossed the border, but you never understood what what was happening there, then you eventually turned 18 and you started doing the same thing because, well, at the end of the day, now I need to work, or whatever the case might be, right? You've had multiple entries, which could potentially have led you to what we call permanently barred because of your multiple entries, because you overstayed, or rather because you stayed being undocumented or out of status for over 180 days, whatever that case might be. And so the U visa kind of pardons this this idea that, well, because you were the victim of a crime of violence inside of the United States, the U visa kind of gives you these waivers, or what we call like perdones, right? Like a forgiveness ticket that allows you to remain here so long as you have reported this crime to the police, that you have collaborated with the police, even if the crime was never solved. And I think that's the most common question. Does the crime have to be solved? No. You only have had to have collaborated with the police in order for it to be solved. If the perpetrator never gets detained, that is not your burden. And so other things that need to be proved is, were you psychologically affected? Were you physically affected? So are there medical records? Are there psychological records that prove that this has affected you? And as a result, you could potentially be eligible for a U visa. T visa is particularly for folks who have been trafficked, right? And I think when we think of trafficked, we think, oh, somebody kidnapped us and held us in this dark room, and we weren't allowed to leave, and they made us do all these things. And that's not always necessarily the case. Trafficked means that we were in a place or in a location where we were not allowed to leave, where our documents were probably taken away. And so that could even mean somebody that came here on a particular work visa, a TN, an H-2A, like farm workers, right? And upon arrival, somebody decided, I am going to take your documents. You're not allowed to leave this location. And I'm also going to withhold your wages. And if you try to say anything against me, I will call immigration on you. So you might as well like keep down and low, because at the end of the day, you're not even from this country. And so this T visa, if the person at some given point is able to get away from this location, this individual can go seek assistance. Hey, this is kind of what has occurred. Also, a police report is not always necessary in this circumstance, because we also don't want to trigger that an individual is making sure it could have that potential to find us. And so long as we can prove these things have happened, we collaborate with resolving the case. At this point, we probably could get, whomever is assisting us could get the police involved. And we're making sure that we're also collaborating with whatever is happening. And so these are different types of visas, particularly humanitarian. And as you can see, that this is the reason why this particular humanitarian unit is only allowed to discuss it with either these individuals in a particular manner. And so that is kind of like the quick and dirty of these of all of these several visas. We could probably come into this if time permits, but I also want to kind of move on and provide folks the opportunity to answer some questions that we received beforehand. So I'll pass it back to Megan.
Thanks, Blanca. Just to kind of touch on overarching, humanitarian cases, there's so many moving parts. So where do you recommend that an office kind of gets started when they get a humanitarian case? And that can be, an SIV, a special immigrant visa, humanitarian parole, temporary protected status. And also too, given that this is a casework area that's kind of rapidly changing, just with the different policies that are changing, regulations that are changing. So kind of where do you recommend, like for an office that's just getting started, where should they kind of take their first step in this kind of realm of casework?
Yeah, I can answer this one. Thank you. I think that the first thing that they need to do is figure out what type of relief they're going to be assisting with. Each type of relief has a different office. They have a different email. There's a different phone number. So they need to understand if they're dealing with a VAWA, if they're going to be working with a T visa, if they're going to be working with a U visa. Once they figure out which type of relief they're going to be working with, then they need to understand determine the stage that the case is at. Right now, unfortunately, these type of benefits take a very long time to get processed and adjudicated by immigration. U visa cases are taking up to 8 years to get a final decision. We know that many applicants start to feel stressed with everything that's going on right now with immigration, and they want to figure out, or they want confirmation of where their case is and what's happening with their case. So the first thing that we need to figure out is what type of relief we're dealing with and what stage that case is right now. If the case is only pending, then basically we will have to explain to the constituent, hey, your case is pending. These are the processing times. However, if there's something else, if the case is outside of processing times, if there's something else that the caseworker can assist with, then the caseworker should be able to reach out to the agencies through either phone number or email and figure out what's going on that case.
That was really helpful, Cristina. Thank you. And kind of what can casework, and this is kind of pivoting a little bit to talk more about family-based immigrant petitions, but what can caseworkers expect in terms of USCIS or State Department processing when working on family-based visa petitions?
So right now, there's a delay, I would say, on almost every case. I'm not going to deny that. USCIS does publishes the processing time. So we have an idea of how long every case is going to take to get processed and adjudicated by USCIS. I would say that at least family cases, a regular and normal adjustment case is going to take at least 2 years. Obviously, caseworkers need to know that every field office, every office that handles adjustment cases, they have different processing times. So we first need to figure out where that person resides, what type of relief, what office has jurisdiction, to make sure how much or how long will that case take. But I would say that right now, processing times are taking a long time. So a case that's only pending for 3-6 months, that's normal. Unfortunately, that's normal. Something that I do want to raise regarding VAWAs, U visa, T visas. Right now for VAWAs, U visa, T visas, when we file those applications, for some reason, USCIS is not issuing receipt notices. The receipt notices are basically the confirmation that they have received the case, that USCIS has the case, and that they will begin to process the case. When there's no receipt notice, when there's no confirmation that the case was filed with USCIS, obviously constituents begin to stress, they're worried, they don't know what's going on. They want to have that confirmation because that gives them the security that they have a case already pending and that immigration knows that they are trying to solve their status. VAWA, U visa, T visas, we're dealing with people who have a lot of traumas. They were victims of domestic violence. They're survivors of domestic violence. So these are people that have been through a lot and now they have to wait, we don't even know how long, to get the receipt notices. So there's not only a backlog with after the case is filed, with how long immigration is gonna take to review that case and adjudicate it. There's also an issue right now with how long it's gonna take for immigration to inform that person that they have the case. So caseworkers need to be aware that they might start getting calls from constituents letting them know that, hey, I filed a case, I'm unable to know where my case is. The attorney is not able to call because we're not able to get that channel of communication. And because there's no proof of, other than the proof of the delivery, there's nothing else that we can use to get information on that case. The caseworker might be the only one who's able to get that information for the constituent.
And for cases like that, Cristina, do you recommend that the constituents, or the caseworkers contact like the USCIS lockbox or like the Office of Legislative Affairs to try and see where they can get that information?
For EU visas, I believe that the office right now handling those cases is the Nebraska Service Center. Blanca, I don't know if you.
Yeah,
okay.
so humanitarian units are both located at Nebraska and Vermont. So each one will have a humanitarian unit. So depending, I think VAWAs and U's are at Nebraska and T's are at Vermont.
Thank you. And then also too, can you, kind of, again, pivoting back to the family-based preference or family-based immigrant visas, can you speak a little bit to kind of the different family-based preference categories and kind of what role that plays in processing in terms of, if you have an immediate relative, if it's a mother or a parent, or if it's a sibling or child, and kind of how that can impact the overall processing and what that looks like?
So immediate relatives and family preference, just to give a brief background, when we discuss immediate relatives or family preference, we're referring to the I-130 petition. For family cases, for someone to be able to obtain a green card, they need to file an I-130 petition. Depending on who is the petitioner, then that petition will be either an immediate relative petition or a family preference. Immediate relative petition means that there's no numerical limit. Once that petition is filed and approved, the person is able to apply for the green card or through adjustment or consular processing, but there's not going to be a waiting time for them to be able to use the petition. On the other hand, family preference does have a numerical limit. There's 4 or 5 family preference categories, and we have to determine who is the petitioner, who is the beneficiary, and what's the country of origin of that beneficiary to be able to confirm the category and the limit of that visa under that category. So for example, if we have the spouse of a lawful permanent resident, those are the F2As. We need to look at the visa bulletin and confirm what's the status of that petition, what's the priority date of that petition, and then we'll have an idea of how long that petition will take to be able, the person to obtain a visa. The priority date is the date when the petition was filed. So if the petition was filed in 2018, that's going to be the priority date for them. However, the petition can be filed and approved in 2018, and it can be 2022, and they can still be waiting for a visa. Because it's limited to only a certain amount of numbers every year, the person might have to wait until that priority date becomes current to be able to use that petition for a green card.
Thank you. And then switching back to the humanitarian side of things, you both have kind of touched on how this space is kind of just really rapidly changing right now. So how can caseworkers utilize AILA resources to track changes to humanitarian programs right now?
Blanca.
I'll just mention, so something that we do is that we attempt to collect trends, right? And so this is also something I mentioned last week. In order for us to assist individuals a lot better is to make sure that we determine whether this is a one-off or whether this is a trend that is happening. And if it is a trend that is happening, then we try to provide a few examples and let USCIS know in a bundle, hey, these 20 individuals or these 100 individuals are being affected by the exact same thing. And so, but before that, we make sure are they being affected because everybody's committing the same error, or are they being affected because the adjudication end is committing the same error, right? And so once we determine if it is an error on the side of USCIS, we gather that bundle, all of the documentation necessary, and say, here's 100 examples, 20 examples. We generally determine that if we've received 10 to 15 examples, we know that it's a way bigger issue, right? And so we provide the agency, here's a trend. It prevents you from reaching out 100 times, and this is what we see. This is what we have determined the issue is, and this is our ask, right? Like, it goes back into how we're formatting our inquiry once raised.
And then kind of also going off of, how this space is kind of rapidly changing, can you speak to where we are on Pasito v. Trump and what that might mean for constituents currently in the refugee admissions pipeline?
Okay. So right now, I would say that the process was suspended, the process for refugee. So right now, we don't expect any decision on those cases. Unfortunately, there's been a lot of back and forth. We do expect some possible lawsuits. So maybe in the future, we will be able to go back to process those applications. But right now, refugees process are suspended.
And for offices that are getting cases where, this program might be suspended and they have family members that are navigating this process, kind of how do you recommend that they interact with these constituents?
We have to be honest. We have to tell them, we have to be honest with them, and we have to tell them that right now we do not expect the decision. We understand that they have, they might be waiting to reunite with their family members for a few years, but we have to be honest with them. Hopefully, we don't know, things might change in the future, and if that happens, then a communication with that office has to be made. But for now, there's not a path, at least through a refugee, a follow to join refugee, there's not a path for them to be able to enter the United States. There might be other ways, depending on the status of the person, if the person is already a resident, if the person naturalized, if something happened, then an attorney can analyze if the person has other options. But right now, as a refugee, that person won't be able to reunite with their family members in the US.
And piggybacking off of that a little bit too, can you speak to kind of we've talked a little bit about the different types of humanitarian visas, but can you speak to a little bit of kind of, how the difference in processing for, like asylum, refugee, the follow to join refugee, special immigrant visa, temporary protected status, humanitarian parole, all of those kind of things?
So asylum and refugee are different. An asylee, it's someone who applied for an asylum in the United States. Once that person obtains the grant of their case, they have to wait 1 year, and then after that 1 year, they can apply for a green card. Refugee, it's different because a refugee, everything is done outside of the country. The interview and the adjudication happens outside of the United States. And once that person enters the country, they enter as a refugee. They also need to wait 1 year to be able to apply for their green card. However, the process is different because one happens here inside of the country and the other part of the process it's outside of the United States. For follow to join, that means that an applicant, a principal applicant who was granted either asylum or refugee status, wants to petition for their spouse or their children. The follow to join application, they file form I-730 within 2 years of getting their status granted. So within 2 years of becoming an asylee, or within 2 years of entering the United States as a refugee, they need to apply for their derivatives to be able to bring them to the United States with the same status that they have. Regarding VAWA and U visas, those cases are handled completely different by the system. VAWA, for example, you have to be either an abused by a US citizen or a lawful permanent resident. So once the VAWA is approved, the person can apply for a green card even, once they get that approval notice, they might not have to wait. That's something that an attorney will be able to determine depending on the facts on the case. For the U visa and for the T visa, the person needs to be on status for at least 3 years before they are able to apply for the green card. So all of these benefits, humanitarian benefits, do provide a path to a green card. However, each of them have different rules and requirements for them to be able to achieve that.
Okay, thank you so much. And Anne, I'll pivot to you for the pre-submitted audience questions.
Yeah, absolutely. And thank you so much, all three of you, for sharing so much incredibly detailed wisdom and just appreciation for how complex and difficult and changing this situation is.
Sorry, and before you,
Go for it.
yeah, I wanted to make a point on the visa bulletin since it was touched on. And so like just wanted to make sure that folks understand that there is a visa bulletin, but it works differently for people who are coming in through consular processing, meaning from abroad into the United States, and for individuals who are in the United States. And so for folks who are abroad, you would look at the visa bulletin that is posted on the Department of State's website. For people who are in the United States, you would look at the visa bulletin that is posted on the USCIS website.
So helpful. Awesome. Really appreciate you clarifying. I actually want to go back a little bit earlier for something we talked about. And kind of maybe dig in a little bit on the specific role of caseworkers, of congressional caseworkers, because as we've talked about and we talked about last week, congressional caseworkers are kind of in a unique position where they are absolutely not immigration attorneys. They can't act as immigration attorneys. They can't give advice. They can't counsel people on their options. But they also do have kind of some extraordinary access that attorneys may not have within the agencies. Blanca, I really appreciate you flagging the specific types of cases where caseworkers may be the only option for people to get information on what's happening. And with all of that said, I think it's also important for folks to realize that every congressional office works very differently, that every office sets its own policy, every office has its own staffing, every office has its own workload. And so there are a lot of really individualized decisions for specific caseworkers. So I think it's difficult for us to offer any kind of rules for, hey, this is how immigration casework should work, because you are all smart, independent, and do your own work and have the judgment, have the advice from your leadership on what makes sense for your office. But given all of that, I think there's a really interesting question here about when to push back on the agency. And Blanca, you raised kind of what to do and thinking about how to follow up when an agency response may not be complete. It may not answer the original question asked. So Meghan, from your experience as an immigration caseworker, I would love to hear just how did your team approach that question? Again, keeping your capacity in mind, when was the appropriate time to push back and how did you do that?
Yeah, that's a great question. And like you said, I think every caseworker in every case, every congressional office, they are smart to know when to push back and kind of when to interact or when and how to interact with USCIS and the State Department, kind of when to be like, hey, we need to, push a lot on this specific case. But a lot of it has to do with, just the sheer capacity of the casework staff too. When I first started, there were only 2 caseworkers for the entire state. And then by the time that our office was completed in the senator's term, there was 5 immigration caseworkers because we had such a huge, just massive amounts of constituent communications coming in that we needed that capacity to be able to reach that, respond to everybody. So, I think for, routine inquiries, if you know that it's a case that's pending, you don't need to be, submitting inquiries every 30 days. If you know that it's within processing times, kind of like what Cristina and Blanca have said, it's, you don't need to be submitting inquiries every 30 days. But, there are times when USCIS might not answer your question, fully, there's, and you have to kind of use your discretion. There will be times where if I would, go through the USCIS portal and ask a very specific question to a, this very specific application, and then when I get the response back from USCIS, they've only given me a status update about the case. They haven't actually given me what I wanted to hear from the agency. And that's when, when we talked about this a little bit last week, building relationships with these service centers and with USCIS staff and then State Department staff too, that's when you can pick up the phone and be like, hey, I got this response from the service center and it doesn't remotely answer my question. So, but really, to like what you said, it's really about caseworker discretion. These congressional offices know how these federal agencies work. And, if they know that the agency hasn't responded fully, picking up the phone and getting a response is going to be helpful. But again, like you said, every office functions differently, and they're going to know what's best for their constituent.
Definitely super helpful. Thank you. And then Blanca, I know you just responded in the chat, but I actually want to pull out this question from Jenna, maybe for a little bit of a broader conversation. So Jenna asks, when we were talking about trends and trend tracking for casework, since we were on this topic, is there a common definition of what constitutes an immigration raid? We are trying to be very intentional about the language we're using, given the impact on the community. Shares a story of a well-intentioned report leading to 100 students absent from a school. So are there best practice tips for accurate, thoughtful reporting? I'd love to have you just answer that one. But then also, I'd love if all three of you could maybe share any insights. One challenge for caseworkers right now, especially, is they are, for some offices, again, case by case, being asked to also kind of support an office's public-facing communications and say, hey, what PSAs should we be sharing about the changing immigration system? Which can also put caseworkers in a weird place for how to give general information that does not constitute legal advice and make sure that you're accurate and correct on this complicated terminology. Any advice, folks?
Taking off my AILA hat for 2 seconds and putting on my organizer hat for a few seconds. So I would say to best kind of not put your office in a particular situation, the best probably advice you could provide your constituent without it being legal advice is for them to seek out information from local community organizations, right? A lot of these organizations already have like know your rights material, all of this that they particularly focus on, including how to well document when they presence ICE. And so I think one of the most common things that we've seen in the last few weeks is particularly what Jenna mentioned, like all of a sudden there's 100+ kids missing from school. And this is something I've seen in various states, not just in DC right now. And one of the reasons is it's because somebody will automatically say, oh my God, I saw ICE, right? And it probably wasn't even ICE. Like it was some other office. And it's just because there is this panic, understanding that their panic is real, but also understanding that we shouldn't continue to feed the panic. We should only be providing resources and education to prevent the panic, right? And so community organizations do that. And it also doesn't put your office in an awkward situation of, well, we're asking them or we're supporting this particular organization. That being said, AILA hat back on. That being said, it is important to understand that, yes, there are particular definitions in what is a raid. And people understand what a raid is, right? And it has to do with a historical context. A raid means they're coming in and they're taking everybody, regardless, right? Of whether they have documents or whatever, they're just coming in and grabbing at any. That is a raid. When we see somebody coming in and they're knocking on doors, and yes, we could see that it's ICE, FBI, DEA, whomever it is, and they're coming to a particular door and knocking and doing arrest, that is not a raid, that it's an arrest. What we saw in DC, that they targeted particular locations, that is more of a worksite enforcement that happens on the side of ICE, HSI, who are particularly performing their duties of making sure that everybody who works there has correct I-9 records, like all of this information, right? And so if they are going to a particular location, it may or may not have to deal with whatever information was obtained from that particular business, right? And so it's not that they went in and just said, we're gonna target these particular locations. There, a lot of the times there's reason behind it, right? And so I think that that's information that local community organizations are tasked with informing. But we could in terms of your particular offices, you could provide some kind of information in terms of if there any pamphlet, is there, does your office work directly with any local community organization, and is your boss okay with having that organization's pamphlets at your office? And so there's a myriad of issues, but yes, the definition we use is super important, and it avoids creating panic.
Super, super helpful. Thank you. And again, I really appreciate the nudge for offices to really build those connections with their local community organizations. Again, the House has just changed its rules last year, and I know the Senate has always had the rules that offices can collaborate with nonprofits on constituent service events. So that is something approved by the House and Senate. So that is an option available to everybody. We are tight on time, but I really feel like I have to squeeze this last one in. Maybe we can do it as a really quick whip round. We've talked about humanitarian cases today, and I know a lot of those often involve caseworkers, attorneys, hearing really difficult stories from people who've been through extraordinarily difficult situations. And that can be really tough to take on kind of those stories, or those traumatic stories, those difficult stories. So for all three of you, any quick tips just on taking care of yourself, keeping your own mental health in good shape so you can continue to support constituents?
I know I leaned on a lot of my immigration casework colleagues, from not just from our office, but from other offices too, to just kind of get me through tough times, and know that, the work that we're doing, even if it feels like we're not making forward momentum, it's still really, really important. And I would also just always tell myself at the end of the day that, constituents, they understand that there might not be anything that we can do, if there's, like in refugee processing, if they're not processing anything right now, they are understanding of that. And just having somebody that's willing to listen and just help them in the ways that they can is really important. And then that means a lot to people. I mean, I feel like so many constituents that I got to work with, they ended up feeling like family with how often we talked. And even if they knew I didn't have updates, it was still nice for them to be able to just talk to somebody and know that somebody was listening. So I always kind of use that as solace in my work.
Same with us. I would say that, discussing with our colleagues, with AILA, when we have our meetings, we usually discuss this between ourselves. We understand what our clients are going through, and we want to be for them. We want to be there for them, to support them and provide all the help they need. But at the same time, we need to provide care of ourselves, because if we don't, we're unable to do it for them. So we have to, be honest with them, but at the same time, when we need to take our time, it's our time. And if we need to, exercise, speak to a therapist, look for other ways to, find ways to relax and avoid the stress from all the work. Everybody has their own ways, but I would say that that's very important, to take care of ourselves.
Yeah. On my end, it's I'm an immigrant, right? I went through the process. And so it is important for me to understand that while that is also something that personally affected me, I have to understand that other people's cases are not my cases, and I cannot absorb them. So I understand that at the end of the day, there's only a limit to what I'm able to do for you. After 5, everything is generally closed. I understand my limits. But keep it in mind that the one thing that I always promise, and on my, for me, is I will work on your case as hard as I wish somebody would have worked on my own. So
I love that. Awesome. And we are at time, so let me do a super quick wrap up to say thank you again so much. Meghan, for jumping in to guest host. We wish you all the best in your post-congressional casework career soon. Blanca and Cristina from AILA, thank you so much for joining us to share your expertise, your wisdom through this really difficult caseload. So we can't tell you how much we appreciate it. For everybody, again, this webinar will be posted, and all of our other casework materials are up at popvox.org/casework. I am always available if you have questions, suggestions for more webinars, suggestions for more resources. We will have some other immigration-related resources coming soon, courtesy of Meghan and her other team, her former team, so stay tuned for those. And again, my email, if you would like to reach out with any of those suggestions, is ann@popvox.org, or reply to our Casework Navigator newsletter.
yeah.
So thank you all again so much. Have a wonderful rest of your afternoon.
And we're also working on making sure that we are ideally connecting congressional offices with our local AILA chapters. So stay tuned. I'll send that information to Anne.
Perfect. Awesome. So lots to look forward to. Awesome. Everyone have a wonderful afternoon. Thank you so much.